Good morning. I'm Kashyap Kamath from BBFNA, and I'm here today to talk about amalgamation of companies as per Indian law. So, first, I'd like to talk about the process of amalgamation, its history, the origin of the word, and some examples. So, amalgamation of a company refers to the merger or combination of two or more companies into one single entity. The process of amalgamation involves the transfer of assets, liabilities, and ownership from the constituent companies into the newly formed company. The goal of amalgamation is often to achieve economies of scale, expand market share, increase profitability, and enhance competitiveness. The word amalgamation dates back to the 15th century and comes from the Latin word amalgamare, which means to mix or combine. In the business world, the practice of amalgamation can be traced back to the late 19th and earlier 20th centuries when companies began merging to achieve economies of scale and expand the market share. Now, I'll be talking to you about the types of amalgamation. There are several of them, such as 1. Horizontal amalgamation. This type of amalgamation refers to the merger of two companies operating in the same industry or market segment. The goal is to increase market share, reduce competition, and achieve economy of scale. Number 2, vertical amalgamation. Vertical amalgamation refers to the merger of two companies operating at different stages of the production process. For example, a manufacturer may merge with a supplier in order to control the supply chain and reduce costs. So let's say I'm company A that's producing a soft drink, and company B is my supplier who produces bottles. So company A can merge with company B to have more control over the supply chain. So that's called vertical amalgamation. Number 3, conglomerate amalgamation. A conglomerate amalgamation involves the merger of companies operating in completely different industries or market segments. The goal is to diversify the company's operations and reduce risk. Number 4, reverse amalgamation. Reverse amalgamation is a type of merger in which private company acquires a publicly traded firm, resulting in the private company becoming a publicly traded company. This type of merger is often used as a way for private companies to go public without having to go through an initial public offering or an IPO. Number 5, a merger of equals. A merger of equals is a type of amalgamation in which two companies of roughly equal size and value merge on a mutually agreed basis. Both companies typically retain their individual identities but are combined into a single legal entity. Keyword legal. And the last type I'd like to talk about is acquisition. An acquisition is a type of amalgamation that is very colloquially used to just mean amalgamation, in which one company takes over the ownership and control of another whole company. The acquiring company typically retains its identity while the acquired company becomes a subsidiary of the acquiring company, losing any individual identity in itself. Now, these are some of the most common types of amalgamation. The type of amalgamation that is most appropriate for a given situation will depend on the specific goals of the company and the objectives involved. One of the most famous examples of amalgamation is the merger of Standard Oil Company and the Rockefeller Oil Company in the late 19th century. This merger formed the Standard Oil Trust, which dominated the oil industry and became one of the largest companies in the world at the time. Another example of amalgamations is the merger of Daimler-Benz and Chrysler in 1998, which then created Daimler-Chrysler AG. The merger aimed to bring together the strengths of both companies and create a global automotive powerhouse. Whether it's a merger of two small companies or the combination of two large corporations, the process of amalgamation has a long and rich history that continues to shape the business world today. In India, the process of amalgamation is regulated by the Companies Act of 2013. The process of amalgamation of two companies in India is a complex and multi-step procedure that involves various legal, financial, and regulatory considerations. The following is a general overview of the steps involved in the process. The first and perhaps the most important step is due diligence, which involves a thorough investigation of the financial and operational status of both companies. This involves a review of the financial statements, contracts, liabilities, assets, and other relevant information. Step number 2, negotiations. Once due diligence is completed, the next step is to negotiate the terms of the amalgamation agreement. This involves discussion of the structure of the merger, the exchange ratio for the shares of the companies, and any other terms and conditions that need to be agreed upon. Step number 3, approval of the board of directors. Once the terms of the amalgamation agreement have been agreed upon, the next step is to obtain approval from the board of directors of both companies. The board of directors must approve the amalgamation agreement and decide whether to recommend it to the shareholders for approval. Approval by the shareholders. The next step is to obtain approval from the shareholders on both companies. The shareholders must approve the amalgamation agreement by passing a special resolution in accordance with the provisions of the Companies Act 2013. These key provisions, which relate to the approval of the shareholders of both companies for the amalgamation agreement, are: 1. The special resolution. The Companies Act requires that the amalgamation agreement be approved by a special resolution passed by the shareholders of both companies. A special resolution is a resolution passed by at least 3/4 of the shareholders present and voting in a general meeting of the company. Number 2. Quorum. The Companies Act requires that a quorum of at least 2/3 of the total number of shareholders be present in order to hold a general meeting for the purpose of passing a special resolution. Notice of meeting. The Companies Act requires that a notice of the general meeting be given to all shareholders, including those who are absent, at least 21 days before the meeting. The notice must specify the agenda of the meeting, including the proposed special resolution for the approval of the amalgamation agreement. Voting by proxy, which is the fourth provision. The Companies Act allows shareholders who are unable to attend the general meeting in person to vote by proxy. A proxy is a person authorized to vote on behalf of the shareholder and must be appointed in accordance with the provision of the Companies Act. Record of proceedings. The Companies Act requires that a record of proceedings of the general meeting be maintained, including the minutes of the meeting, the text and the special resolution, and a record of the votes cast by each shareholder. It is important to note that these provisions may be subject to change and that the specific requirements for the approval of the amalgamation agreement may vary depending on the nature and size of the companies involved, as well as the jurisdiction in which they are located. Step number 5 for amalgamation would be approval by the regional director. After obtaining approval from the shareholders, the next step is to file an application for approval of the amalgamation with the regional director of the Ministry of Corporate Affairs. The regional director must approve the amalgamation agreement and may attach certain conditions to the approval. Step number 6. Approval by the High Court. After obtaining approval for the regional director, the next step is to obtain approval from the High Court. The High Court must approve the amalgamation agreement and may attach certain conditions to the approval. Filing of documents with the Registrar of Companies. This is the final step. Once the amalgamation agreement has been approved by the High Court, the last step is to file the required documents with the Registrar of Companies. This includes the amalgamation agreement, the order of the High Court, and all other relevant documents. The specific requirements and procedures may vary depending on the nature and size of the companies involved, as well as the jurisdiction where they are located. However, the basic process remains the very same and involves a series of legal and regulatory approvals that must be obtained in order to complete the amalgamation. I would like to conclude by remarking again that amalgamation is the combination of two or more companies into a single entity. Companies engage in amalgamation for various reasons, including but not exclusive to cost savings, increased market share, access to new markets, improved efficiency, and increased financial strength. However, it is important to note that amalgamation also has potential disadvantages, such as decreased competition, cultural differences, and integration challenges. Companies should weigh the potential benefits and drawbacks before embarking on an amalgamation. Thank you for your time and attention.